Good morning, everyone, and thanks for joining today's Brodie's webinar on the topic of remote dispute resolution. Today, we're particularly focused on how things have changed over the last 18 months or so, and I'm joined today by colleagues of mine in the Brodie's dispute resolution team, Jane Rattray and Erin Hunt. We're going to look at three forms of dispute resolution today, so court proceedings, arbitration, and mediation. And as well as discussing changes we've seen and experienced over the last 18 months, we'll discuss what we expect to see in the future, and in particular, what lessons have been learned in terms of increasing the toolbox for efficiency in terms of handling disputes as courts and tribunals have become more used to holding remote hearings. Okay, so moving on to discuss court proceedings with Erin. I suppose most of you, when you think about dispute resolution, will think about court proceedings as the most traditional method. And Erin, you've been involved in a number of remote court hearings over the last 18 months or so. Can you tell us a bit about how these have been operating?
Yeah, of course. So last year, in response to the pandemic, the Scottish Government passed the Coronavirus Scotland Act 2020. These essentially altered the law in respect of the conduct of civil court proceedings, among other things. The biggest change that we saw really was that anyone participating in civil court proceedings in Scotland could take part by way of video conferencing or by telephone from any location. So effectively, the requirement that parties physically attend court was suspended. For the bulk of that time, we saw procedural hearings being heard over the telephone, with more substantive hearings such as debates and proofs, that kind of thing, being carried out by WebEx or video conferencing. From the start of this month, though, at least in the Sheriffdom of Grampian, Highland and Islands, all hearings are being conducted via WebEx unless there's some compelling reason that that can't be done. So I've conducted a couple of hearings via WebEx now. I think it works really well for more procedural hearings. I would imagine that conducting a proof, for example, where evidence is being led, witnesses are being questioned, that might be much more challenging.
And I suppose this is obviously quite a big shift from people appearing in court. Can you tell us a bit about the practical arrangements that are made for remote hearings?
Yes, so as I mentioned, over the last 18 months or so, most procedural hearings were being held by telephone. Parties were to email the court 3 days prior to the hearing with brief written submissions for the hearing and a note of the contact details for the individual that was going to be appearing. If the written submissions that were provided were such that a full hearing was not required, so for example, if both parties were looking to recall assist, for example, or if a decision was to be made in terms of the type of hearing to be fixed next in procedure, and the sheriff was able to do that with the information available to him or her at the time, then the case would be dealt with administratively. And what that meant really is that there'd be an exchange of emails between the court and the parties to the action, or between the respective agents, and an interlocutor at a court decision would be issued shortly thereafter. Where a hearing was required, court would begin at 10 AM, just as it had pre-COVID, and the sheriff clerk would simply work through the list of cases, phoning the parties to each case as it became their turn. The rest of the hearing was pretty much then just conducted in the same way that it was pre-COVID, with the obvious exception that parties wouldn't be able to see each other. With the shift to WebEx recently, written submissions no longer require to be lodged as a matter of course. So parties provide their contact details 3 days before the hearing, and then essentially one of two things will happen. In some instances, the court will email you to confirm maybe the day before the time for your hearing, and in other situations, you'll simply join an online waiting room from 10 AM on the day and are basically just let into the room or into the hearing once it calls.
And if you compare this to the traditional pre-COVID approach, what do you think works well and what doesn't work as well or perhaps needs improvement?
I think one thing that's, and probably the main thing for me certainly, that's greatly improved is the general efficiency of the court. So prior to the pandemic, you'd have, say, your ordinary court on a Thursday morning. It would require all agents to be down at court from 10 a.m. on the day of the hearing, and they would all simply have to wait until their case was called. So in my experience, that sometimes resulted in waits of 2, 3, even 4 hours for the sake of a 10-minute hearing. I can imagine too that where witnesses are involved, there are certain positive aspects to remote hearings. For example, witnesses can be at their home or their place of work, ready to join the court hearing and give evidence as and when required, rather than having to travel to a court, which could be some distance from them, and potentially having to do that for over the course of a couple of days. One issue with that, though, it becomes almost impossible to ensure that witness evidence is being given securely and that the witness isn't being coerced in any way. So there was an extreme example of this. We saw, I think it was back at the beginning of the pandemic, in the USA, where a victim of assault was giving evidence in her assault case. She was in the same property at the time as the alleged perpetrator, and it was only because the prosecutor had somehow noticed that both parties seemed to be in the same property that the hearing was brought to an end then and then. What I do find more difficult, or certainly did find more difficult when hearings were being conducted by telephone, is not being able to see your audience. So obviously when you're in a courtroom or even on video conferencing, you can see the sheriff and you can gauge how he or she is reacting to what you're saying. But on the telephone, you're effectively talking into the abyss and just hoping that the call hasn't somehow disconnected without you noticing. And you've got the obvious issues too, in terms of risk of IT problems causing delays. And I think you actually have to be more prepared in some ways for remote hearings than you would in a courtroom. So, for example, if you were looking to ask the court to allow the lodging of a document, you can't simply tender this at the bar in the same way that you would have done before. You would have to have the document sent to the court in advance of the hearing to allow you to do that.
Yeah, I think the point you made about reading the judge is a really good one, because if you're in the middle of a detailed submission, you want to see how the judge is reacting. You want to tailor your submission appropriately. Similarly, when examining a witness, reading body language is important, and you that will play a part in framing your follow-up questions. Mm-hmm. So how do you envisage court proceeding or court hearings being dealt with going forward? Do you think remote court proceedings are here to stay?
Well, as you can imagine, there's been a lot of kind of articles, debates, and whatnot within the legal profession around the place of remote court proceedings as we hopefully emerge from the pandemic. Many are concerned, I think, that the usual gravitas of a courtroom will be lost where remote hearings continue to be conducted. It also makes the transparency of proceedings more difficult. So prior to the pandemic, members of the public would often sit in the public galleries of the courts just to observe proceedings and see what was going on. My understanding is that it is possible for members of the public and the media to contact the court and ask that the WebEx invite be forwarded onto them for a particular hearing, but it's certainly not accessible as it once was. I have had some experience of clients joining court hearings by phone, not as witnesses, but simply to listen in to proceedings, and the court certainly haven't had any difficulties with that. In terms of moving forward, I think the changes to the law that I mentioned earlier were originally due to expire on the 30th of September this year. However, the Scottish Government have recently passed new legislation which extends parts of the Acts, the Coronavirus Acts, until the 31st of March 2022. So one of the parts of the Acts that was extended was the parts which related to the changes to the conduct of civil business in Scotland. We saw in the beginning of September this year, the Scottish Civil Justice Council issued a consultation and a proposed set of draft rules which dealt with various modes of attendance at court hearings and civil proceedings. That consultation closed just last week, and as far as I'm aware, we're still waiting to see what responses were received to that consultation, but that'll hopefully not be too far away. Personally, I expect that remote hearings are going to be around for some time, regardless of what the longer term plans might end up being. I think it's going to take some time to recover from the effects of the pandemic and just to get things back on track. But after that initial resettlement phase, I think the future is less clear. I suspect, and personally I hope, that procedural hearings will continue to be conducted remotely, but I expect that the courts and probably the judges too are going to be keen to return to normality as soon as possible when it comes to these more substantive hearings.
Yeah, I think it's all about choosing the right type of hearing for the particular case. And I know there is some suggestion that for commercial actions in the Sheriff Court and the Court of Session in particular, that they may keep remote hearings even for quite a lot of the substantive proceedings, but time will tell.
Absolutely.
Well, thanks, Erin. I'll kick off a discussion about remote arbitration. I suppose even pre-pandemic, one of the main advantages that arbitration had over court proceedings was that the existing procedures were already pretty flexible, and because of that, they were well designed to deal with changes in circumstances, and they were also already designed to deal with cases where parties, lawyers, and tribunal members are in different locations, because that's obviously a very common feature in international arbitration. So it's certainly fair to say that parties to international arbitrations have benefited from the fact that tribunals generally have quite a lot of power and discretion to tailor procedure efficiently in order to suit prevailing circumstances, and clearly that has advantages in a pandemic.
Ryan, you're probably the most experienced of all of us in dealing with arbitration. Would you say it was fair to say that parties often being in different locations, remote hearings were already quite often being used pre-pandemic in arbitration?
Yeah, remote hearings are certainly not new in international arbitration, far from it. So prior to COVID, most steps in international arbitration were already done remotely. So holding case management conferences by video or telephone would be an example, exchanging submissions and documents by email or data room, unlike some old court rules that require that to be done by post or even fax. International arbitration is more advanced in terms of exchanging electronically, because that clearly maximizes efficiency where parties, solicitors, and tribunal members are in different locations. It's also an important factor that international arbitration doesn't necessarily face the same time and cost restraints as national court systems tend to face. So there was already actually a bit of a focus on looking at ways to increase efficiency by using sophisticated video conferencing technology. In saying that, hearings on the merits or on major procedural issues were usually still dealt with as physical meetings before COVID. So the pandemic has forced even the arbitration community to adapt to conducting proceedings in the face of the travel restrictions that came in, social distancing measures, etc.
And how have you seen things develop and adapt since March last year?
I suppose initially at the start of the pandemic, a lot of substantive hearings were postponed due to travel restrictions and other measures that came in. Like with everything else, there was an immediate need to assess, well, what can we do, what can't we do in what was a changed world. We did see a quick response from the International Court of Arbitration to really encourage remote arbitration. As early as, I think, early April 2020, it published a guidance note pointing out that if remote hearings can be adequately implemented, then there will actually be less disruption to businesses, which are at that time going to need disputes quickly resolved in difficult times in order to move on and in order to focus on keeping things going commercially. So it was pointed out that the arbitration tribunals can take measures, including resolving disputes on the basis of documents only, if appropriate, or by using audio conferencing or video conferencing for any necessary hearings, even substantive hearings. And I think several tribunals and arbitral institutions quickly adapted by ordering remote hearings. And since the start of the pandemic, relatively few hearings have been held entirely in person. Most have been semi or fully remote. And according to a survey conducted by the International Chamber of Commerce, by Q4 in 2020, 71% of users had participated in fully virtual hearings, which was an increase from 36% in Q1.
Ryan, you mentioned there that arbitral institutions reacted quickly. Can you talk a little bit more about how these institutions have reacted? Yeah, so initially, given the absence of express provisions addressing remote hearings in most arbitral rules or in national arbitration legislation, many of the institutions released, I suppose, a reactive guidance, but now we're a further step forward, and many have now taken steps to update their rules to provide expressly for the use of remote hearings. There's also been non-institutional guidance in the form of external protocols, perhaps most notably the Seoul Protocol on video conferencing in international arbitration. That was actually something that had been in discussion before COVID, I think since 2018, just to reflect the increased global nature of international arbitration. And it contains a range of useful practical advice on issues like limitations on who can be present with a witness giving evidence remotely, how the witness should appear on screen, production and exhibiting of electronic document bundles, and it also gets into technical requirements and testing of technology.
So do you think international arbitration is now in a settled place in terms of conducting substantive proceedings remotely going forward?
Well, even with institutional guidance documents, protocols, and even updated institutional rules that I talked about, there is still complexity that needs to be considered and ironed out in the context of remote arbitration. What we'll see is utilization of different forms of hearings and even hybrid hearings, with some parts held remotely or fully remotely, others perhaps with physical meetings. And I suppose being able to tailor proceedings and hearings does result in significant time and cost savings in terms of, in particular, negating the need for travel, and that can have a number of positive impacts. As well as reducing cost, you're likely to be able to find an earlier hearing date because you're not having to factor travel into diary arrangements. But it is absolutely vital that for all possible forms of remote hearings, parties and tribunals are assessing the relevant regulatory framework, in particular the law of the seat of the arbitration and any governing arbitration rules, because some national laws and arbitration rules will expressly allow remote hearings, but others don't. And if there are no express permissive rules, then it's going to be necessary to consider whether the tribunal's broad powers to determine procedure are enough for the tribunal to order remote hearings or semi-remote hearings.
And I suppose in that sense, the tribunal has to be mindful of limits on its powers. Yeah, so the tribunal's powers are broad in terms of fixing procedure, but they're not without limits. And one very important limit is the terms of the parties' arbitration agreement, which might be in the commercial contract. It's the clause that essentially sets jurisdiction to arbitration. So if the parties have agreed on a certain procedure within that clause or arbitration agreement, so perhaps they've agreed to hold a physical hearing, then following a different procedure potentially risks arbitral awards being set aside on the basis that the agreement wasn't followed. It's also necessary to consider whether remote hearings might conflict with the laws of the
the seat of arbitration, as I mentioned. So I think there has been some comfort given to practitioners that recent research suggests that none of the signatories to the New York Arbitration Convention are actually subject to laws which grant an express right to a physical hearing, but arguments could still be made that a right can be inferred by laws, and that brings into focus potential due process arguments as to whether a party's rights have been infringed by the way hearings were conducted.
Mm-hmm. And presumably those factors are going to be of particular importance where one party is seeking to insist on a physical hearing.
Yeah, exactly. So if you've got one party seeking a remote hearing and the other seeking a physical hearing, then the tribunal then faces a delicate balancing act between, well, firstly, the party's right to be heard, and secondly, the tribunal's obligation to conduct the proceedings in an efficient and expeditious manner. And that's a balancing exercise that requires consideration of a very wide range of factors. So it's going to be, the tribunal is going to be thinking about, well, what is the justification for a remote hearing? Does a remote hearing suit the content of the hearing? Does a remote hearing prejudice either party? You know, the envisaged timing for the hearing and potential delays if it's held physically, and a comparison of the costs between a physical hearing and a remote hearing will be factored in. You know, they might be relevant, but they won't trump any potential prejudice to a party. So tribunals will have to evaluate each case on its merits in order to minimize the risk of later due process challenges. I think as we come out of the pandemic and remote hearings become increasingly used for reasons of, I suppose, efficiency rather than absolute necessity, which has been the case until, I suppose, recently, then the impact that these hearings can have in due process is likely to fall under greater scrutiny. It may well be that courts in arbitration-friendly jurisdictions like the UK will perhaps favour upholding a tribunal's decision to hold remote hearings. But of course, if the courts are getting involved, that's another layer of cost. It's less efficient. So I do expect that there'll be some caution, at least until case law develops.
Mm-hmm.
Okay, I think that probably covers things in terms of arbitration. So we'll move on to have a discussion with Jane about mediation and remote mediations and how things have changed over the last 18 months or so. Most of you will probably already know this, but for those of you who are less familiar with mediation, it's basically a process where a neutral, independent mediator works with parties and assists them to work out their own solution to a dispute rather than imposing a decision on them. So mediations traditionally have been face-to-face, and people have tended to think that plays a big part in why they work. Parties and their legal teams and the mediator will all attend at the same venue, set up in different rooms. Mediator will work both rooms, speaking to both teams, and if it's appropriate to do so, bring them together to have joint sessions. In principle, there's no reason why mediation has to be face-to-face, and you know, remote mediations were a thing before COVID, often held by commercial clients, particularly in international disputes where there were time and cost concerns in relation to bringing everybody together. But we have certainly seen a significant increase in remote mediations as a result of the pandemic restrictions. And Jane, you've recently been involved in a remote mediation. Can you tell us a bit about your experience of that?
Yeah, of course. So I was involved in a remote mediation, which was actually pre the pandemic restrictions. Our case was raised against our clients at Bristol High Court by claimants who were based down in Bristol, and our clients were based up in Aberdeen. And it was all about a contract to contract for purchase of a villa over in Florida. So to save on costs, as we would have had likely to have travelled to Bristol for the mediation, we managed to persuade the claimants to hold the mediation remotely. And we actually did that by way of teleconference with the claimants, their barrister and lawyer, and the mediator all being in Bristol at the claimant solicitors' offices, and then our clients and myself being at our offices in Aberdeen. So the main benefit of this to our clients was that there was significant cost savings in terms of travelling to Bristol themselves, and also paying our costs and time for travel to Bristol. And also they were saving on room hire costs, as quite often a mediation can be held in a hotel or another venue where you've got to pay for the room. In that situation, our mediation lasted for about 10 hours, so it was quite a long day, but we did successfully manage to reach a conclusion, and we signed the consent order in the court action the same day. So that was a good outcome for our clients, but also for the counterparties.
And how did it all work? I suppose practically, what were the arrangements?
So what usually happens is that the mediator sets up the mediation meeting using a video conferencing platform. So it'll be Microsoft Teams or Zoom, which most people will be familiar with using by now. Provided that the parties have a reliable internet connection, then there's a variety of different devices that can be used to participate. My experience is that remote mediations tend to work better where there is a video connection for all participants, but it is also workable to mix and match video and teleconferencing. For example, if you've got an elderly client who's not used to using modern technology, the mediator will send each party a link to the meeting, and then all you need to do is click on the link and follow the instructions to get into the mediation.
Sounds quite straightforward then, even for
Yeah.
those of us with relatively little technical expertise. Did you find that there was any difference between preparing for a remote mediation and one where everyone was in the same room?
Not really. The preparation is pretty similar, apart from there's additional IT steps that you have to take. So obviously all parties need to download the video conferencing platform, and the parties should also test their connection. And most conferencing platforms will have a test function on their website. You need to send the mediator the email addresses of everyone attending so that they can be invited to join the mediation. And usually the mediator will have a test meeting with each party just to make sure the technology is working and answer any questions that the participants might have about the IT side of things.
Mm-hmm. Okay. And what about on the day? Can you maybe talk us through the process on the day of a remote mediation?
Yeah, so once the mediation started, the mediator will invite all of the parties into their pre-assigned breakout rooms, explain to each breakout room how the process is going to work, and then in the private opening sessions, mediators will ask if a joint session is wanted by the parties, and if so, the mediator can bring all of the parties together into a virtual joint session. And really, aside from the technicalities, the mediation proceeds as it would in a face-to-face mediation.
And I suppose in a face-to-face mediation, you have some pretty frank discussions with your client, sometimes with the mediator present, other times without the mediator present. How does that work in terms of remote mediation? Is there any risk that everybody's just back in the same room and the other side are hearing what you're saying?
Yeah, so the breakout rooms are private, so they can only be accessed by the parties given permission by the mediator, and you should be able to see by VC and audio who is in your breakout room. So you should know who you are speaking to at any point. If your clients do have concerns about privacy, you can mute the breakout room, or you can log out of it and have a separate video conference or private telephone call to ensure privacy. There's also been reports in the media about uninvited parties accessing Zoom conversations, but that's prevented by the mediator making sure that the mediation meeting is private and password protected, and requiring access to the mediation via a waiting room so that nobody can access it without the mediator's permission.
Okay, and I think you mentioned that in the mediation you dealt with an agreement was reached and it was all documented. Now, obviously, if everyone's in the same room, they can sign the same bit of paper. How was that dealt with at a remote mediation?
Yeah, so it's pretty much dealt with in the same way. We circulated drafts of the settlement agreement by email, and these were agreed between the parties. We then signed them and scanned copies of these versions, exchanged copies and counterpart by email on the day. So it all worked similarly to a face-to-face mediation. Ideally, you would like your settlement agreement to be signed on the day, but if that's not possible, then you can agree the wording of your settlement agreement and then put in place some arrangements for signing afterwards. It's also possible to execute by electronic signature, but we're running out of time as it is, so I won't go into that just now.
I think we could probably do a session on electronic signing alone. So just to finish up, Jane, in your experience, would you say remote mediation worked just as well as face-to-face?
Yeah, I would say that it does. Might be that some people are a bit skeptical about remote mediation because you don't get the face-to-face interaction. But my experience was that it was a good alternative and it didn't diminish the chances of reaching a resolution. So I would certainly be encouraging parties to consider remote mediation. I think it's an effective alternative method of resolving disputes.
Mm-hmm.
Okay, well, I think that probably brings us to the end of today's discussion on remote dispute resolution. I'm conscious that we're already a few minutes over time, so what I'd propose to do is just deal with questions by email. If you haven't asked a question but you want to, you can get our email addresses on the correspondence that went out or on our website. So please do feel free to email us with any questions that you have. But other than that, just like to thank you all for coming. Thank you very much.
Thank you.
Thanks.